The purpose of the webinar today is to assist you in getting paid first time for special preparation forms and unused preparation forms over 3 hours. By the end of the webinar, you'll have an understanding of the most common reject reasons and further understanding of the information we require for unused preparation claims and special preparation claims. So we're going to start by talking about the general issues that can affect both special prep and unused claims, with some hints and tips to avoid claims being rejected. Looking at the figures from the financial year 2023 to 2024, the CCU received 330 new special prep claims, and of these 65 claims, equating to 19.7%, were rejected. 101 claims were subsequently redetermined, and we received only 4 written reasons requests. So that's where firms indicated they wish to bring the matter before the cost judge. For unused preparation forms over the same period, we received 343 new claims, and of these 60 or 17.5% were rejected. 80 claims were subsequently redetermined, and we only received 3 written reasons requests. Looking at common reasons for rejects, the claims that are rejected across both work streams, the most common reasons are the mandatory forms, the LSP2 and the LU1 forms aren't being provided. The declaration on both forms confirm that remuneration for the work has not been sought elsewhere, has not been completed. This is the equivalent to the forms not being signed, so we can't process a claim until this has been done. Many of the other issues we come across relate to missing supporting documents or a lack of supporting narrative. The forms have been designed to target the type of information that we require to undertake the assessment. By using the form as a guide and completing all of the relevant sections to help you avoid many of the issues that may trigger a form being rejected or hours being reduced because we've not been able to do a full assessment. We recognise that both parties can take steps to avoid the need for claims to be rejected, and so we can increase the number of claims that we're able to pay first time. Providers are asked to ensure that the correct forms are completed and uploaded alongside all the necessary supporting documents. You can also ensure you respond promptly to any requests for further information that are made via the Criminal Crown Court Defence portal. While claims that have been submitted without the mandatory forms or incomplete declarations will be rejected before they're allocated to a determined officer, once the claims are allocated, colleagues are expected to triage all claims on receipt and request that any non-mandatory missing information be provided within a specified time period. In instances where there's some missing information that might affect a discrete area of the claim, so for example, you're claiming for a number of electronically served documents, but there's been an issue in accessing one of them, the team is encouraged to complete the assessment on those areas that they can, allowing a partial payment with a view to revisiting the outstanding areas once the issue is resolved or further information is provided. All special preparation and unused preparation forms submitted to the CCU must be accompanied by either supporting attendance notes or a work log. Whichever format you choose, it needs to contain the following information: when the work was undertaken, so the dates; who undertook the work, so the name of the fee earner; how long was spent, and what was done. This should include a brief description of what material was reviewed, how it was reviewed, for example, with keyword searches undertaken if appropriate, and an indication of its relevance to the case against your client. Where the claim relates to the consideration of electronic material, we need to see that electronic material, and there are a number of mechanisms you can get it to us. CCCD. So this is best for small tranches of material and can be uploaded into a variety of formats. Access can be provided to us via the Crown Court digital case system, and the assessor will contact you either via CCCD or email to ask for access to be given. If material isn't available through CCDCS but has been uploaded onto egress, the assessor may request access. Material can also be uploaded onto the Galaxy Secure File Exchange. If you're unable to upload material, you can send an encrypted USB stick with the material on and provide the password to the assessor. Due to data protection, we're not able to return any material sent in an unencrypted format. So if you need the USB stick to be returned, you will need to liaise with the assessor to make arrangements to collect the material from the assessing office. Claims are assessed on the basis of reasonableness, and we take into account factors such as the allegations faced by the client and the nature of the case, how much material is likely to be directly relevant to the case against them. For example, is the prosecution alleging that they're a controlling mind, or are they only alleged to have played a minor role? That being said, we appreciate you'll want to consider all of the material that's either been served or disclosed to you in a case, and we'll never say that you shouldn't look at it all. But we expect that you will need to spend longer reviewing the material most relevant to the case against the client, and that the least relevant or clearly irrelevant material should only require a cursory review. We also consider the volume of material, how much information is on a page, and how complex that information is. For example, we would look at how long it takes you to look at an invoice as opposed to a more in-depth report. Essentially, what we want to see when we look at a claim is a completed mandatory form with the declaration ticked. All sections of the form relevant to your claim have been completed and they address the issues raised on the form. For example, the information about the case details or the justification for the hours claimed. Remember, the larger the claim, the more details required. It's more difficult to assess a high-value claim if only a small amount of supporting information is provided. All relevant supporting documentation should be provided and it should be clearly labelled so it can easily be identified. And we can see if the electronic material is accessible via CCDCS, egress, or has been uploaded to Galaxy SFE. We'll now take an overview of special preparation claims. Litigators can submit a claim for special preparation on Crown Court cases where a graduated fee is payable and the pages of prosecution evidence, or PPE, exceed the 10,000 page threshold of the graduated fee scheme, or the prosecution have served electronic material which has never existed in paper form and it's not deemed appropriate to include it in the PPE calculations. Obviously, in many cases, electronic material does end up forming part of the PPE calculations, but when you're completing the LSP2 form, it's really important that we can clearly see which header you're claiming under, as it might impact on the outcome of the assessment. The LSP2 form should be downloaded from the LAA website to ensure you're always using the most up-to-date version of the form. While we've tried to make the form as straightforward as possible, only asking for material that we need to do the assessment, there is a step-by-step guide available on the LAA Learning website, which is accessible via the links on the slides. The criminal legal aid remuneration regulations are really specific as to what can and can't be paid as special preparation. Essentially, in cases where you're claiming special preparation for pages in excess of 10,000 pages, we can only pay for the time deemed reasonable to read those pages in excess of the 10,000 pages, with the first 10,000 pages being covered by the graduated fee. Where you're claiming for the consideration of served electronic material, we can only pay for the time deemed reasonable to view that material. So on the flip side, there's a variety of work that's excluded from payment as special preparation. And basically any work which is not either reading the pages of served material in excess of 10,000 pages or viewing served electronic material is excluded from payments. The types of excluded work we most commonly see in claims for special preparation include the consideration of served audio or video material, and there are appeal decisions such as the case of R versus Reed and R versus Udin, which support that stance. Any ancillary tasks arising out of the consideration of served material, which might include the preparation of schedules, chronologies, dramatis personae, or cross-referencing. And their exclusion from the scheme is supported by the cases of R versus Nazir, R versus Sterinsky, and R versus Swaby. We're also unable to make any payment for unused material. And that will take us on to the next section of the webinar.
Okay, so we're going to move on to the unused preparation portion. As you know, back in 2020, the regulations changed, which allowed for fee earners to be remunerated for considering the material disclosed within the case but is not served, but may help the defence in their case. So this is for all cases on indictment to the Crown Court where it progresses past the guilty plea. Now, the first 3 hours within this unused preparation is claimable as a fixed fee. 10 to 30 hours are dealt with our graduated fee team, and 30 hours plus are dealt with ourselves here at the CCU unit. All claims over the initial 3 hours should be accompanied by the mandatory LU1 form, and for any claims that are 10 hours or more, you should also provide attendance notes or a work log showing what material has been considered and when. On the next slide, you will see how you can download the forms. We would ask providers that they download them and not to keep copies, as we do often change our forms. This is to give you the best, to give us the best information that we can. The forms can be downloaded from the gov.uk website, and we've also recently published some helpful videos on how to complete these, which will shortly be available. So, what work is not payable for unused material preparation? So any served material, including statements, phone data, documentary exhibits, interviews, but also any served material that is not payable under special preparation, such as CCTV or audio. We also don't remunerate for defence-generated material, material that is served in relation to the proceeds of crime, and material that is disclosed after the litigator or advocate is no longer working on the case. We often see providers making claims for things such as index pages, correspondence from the prosecution, pages for things like cover sheets, blanks, title pages, or separators. These are also not classed as unused material. Okay, so what do we take into consideration when we're assessing our claims? So in a nutshell, we consider obviously the material itself. So as Lindsay mentioned for special preparation, we look at how heavy dense the material is. Is it things like statements or records of interviews, which will take you longer to consider? Or is it such items such as images, invoices, things that will take less time to consider than the heavy dense material? We'll also look how important the material is to the client's defence, the nature and the complexity of the material, and we also look at the notes on taxation that are provided by the fee earner. Again, just as special preparation, we would expect the larger claims to have more extensive notes, and we would expect the fee earner to provide more extensive work log, what material was considered when and by whom. We take all this into consideration and we look at the relevance. So we might look at the case summary, for instance, or we might look at the jury bundles to see whether or not anything fits in. Okay, so what work is payable? So we're looking at the electronic material. As technology has progressed, the terminology pages of evidence or pages of disclosure is technically not correct due to the increasing amount of material that is derived from electronic devices. As such, when we consider the material in question, it would not be right to make assessments based on a rate per page. Electronic material disclosed would normally be considered using search and filter functions, and so actual time considering the material would be more appropriate. Most of you who deal with this type of material would have heard of the SVS cost judge decision, where it's been famously quoted as describing phone records are like filing cabinets, in a sense where each section of the report contains a specific subset of data, so it is reasonable to draw a distinction between the communications and, let's say, those that hold maybe just the metadata. From your work log or your attendance notes, the determinant officer should be able to see what has been considered and why. If the fee earner is claiming 20 hours considering the communications data and at equal time considering the metadata or things such as pre-populated images, this is going to be taken into consideration by the determined officer. For items such as audio and video material, we would usually agree around 1 to 1.5 times the running time. But again, this should be noted in your attendance log. If a fee earner is considering things like 4 hours worth of CCTV that is being produced from 2 a.m. to 6 a.m., nothing has happened. We would want to know why this hasn't been sped up. What has been so important regarding this material that you had to spend more than the running time to consider? Running time should be supported by documentary confirmation of the actual time. So, for example, copies of the MME placeholders, viewing logs or disclosure letters and emails from the prosecution. At this stage, I would also like to note that we do not agree time for ancillary work undertaken on the unused material. Time claims should be for the consideration of this material only. So items such as production of schedules or cross-referencing to the used material would not be payable. If we see this on the work log, this will be taken into consideration when we make our assessment. Where the status of the material is not clear, which can happen if the material is disclosed informally, all members of the defence team, so the litigators and counsel, must reach a consensus on how they wish to make this claim payable. This happens sometimes in court, so it could take that unused material has been changed to served material. However, it doesn't get put on the LAA report. If one party makes a claim that provides evidence that this material is now served, we cannot make a payment to another party for the material to be classed as unused and vice versa.